Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 250 of the NCDWI Guy podcast. On today's episode, I have a special treat for you. Guest Tony Scheer, a superstar of criminal defense, is on the podcast sharing his wisdom about attacking a criminal case from the word go. This has been one of my favorite recent episodes. I learned so much today on the podcast from Tony. Very excited to share the conversation with you all. Tony graduated from UNC School of Law in 1992, where he was a member of Law Review. He, after law school, completed a clerkship with the Honorable Henry Morgan in the Eastern District of Virginia. After his clerkship, he went to Charlotte, where he was a member of the DA's office from 1993 to 97, and then joined the firm he is currently a member of, at the time, Rawls and Dickinson, now Rawls, Scheer, Clary, and Mingo, in 1997, and has been concentrating in criminal defense since that time. Has obviously decades of experience in defending criminal cases, and has, as a part of the firm that he works at, this attack mentality on criminal cases. You're going to hear what that looks like, how that is executed, and ultimately why it is so helpful in criminal defense and why it is a part of the core identity of Tony's firm. So excited to share this episode with you, and I hope you enjoy the conversation as much as I did. Tony, I'm super excited to have you on the podcast and go through this attack model of defending a case. I love kind of violence of action, aggressive beginning. And so I'm pumped to kind of walk through what that looks like on your end, and very excited to have somebody as prestigious a defense lawyer as you are on the podcast. So thanks for coming on and sharing your wisdom with us.
Absolutely. Yeah. Well, that's very kind words of you. But I think on one level or another, everybody does some of these kind of, I love the way you characterize it, violent tactics up front. Everybody sort of has a way of cranking up a case. And I'm glad to be here. Thanks for inviting me. And I'll share how we do things here at this firm. And maybe some people will get some ideas off of this. Who knows?
Well, before we kind of dive in on that front, just to kind of get a little background, I think it's always helpful for everybody to kind of hear how each guest on the podcast kind of got into criminal defense and kind of what led down that path. So what made you want to become a lawyer to begin with, and then what led you into the criminal defense pathway?
Yeah, well, first of all, I'm a second or maybe third career person coming to the law. I was out of college for 10 years before I decided to go back to school and become a lawyer. And
what were you doing in the meantime?
Well, I mean, the major thing, the thing that ate up probably 8 or 9 of the 10 years was that I went into business. I owned a retail water sports store in Durham. We had 2 locations ultimately, one in Durham and one in Raleigh. But I was in the retail business. And it was water sports in general was just something I loved. I'd always done. And, coming out about 8 or 9 years in, I'd gotten really burned out on that. But I decided to go to law school because I wanted to help people. It was the 80s, and I thought that coming out of the era, I'd voted first for Jimmy Carter, my first time ever voting. Ronald Reagan had been president for 8 years, and I really thought that we were going into another period of kind of like, civil unrest. And I wanted to be in a position to kind of help. I was raised in a household, a social justice very much aware household. Both of my parents were involved in all kinds of causes. My dad, even when we were very young kids, went down to Mississippi with the Freedom Riders in the early 60s. And that's just kind of where I was raised. So my thoughts ran to that. And when I thought that the country may be going back to a period where civil disobedience was going to become a thing to do again, I thought, I really want to do that. That was coupled with the fact that, honestly, I was completely burned out on being a business owner, and being in the retail business in particular, and being involved in a retail business that had everything to do with all of my loves. And frankly, I spent all of those seasons, the scuba dive season, the sailing season, the fishing season. I was just busy as could be at the times that I wanted to do my own thing. So I wanted the hell out of retail business in general, frankly. I wanted to be somewhere where I could help people. So I decided to go to law school. Did a couple of other things in the transition, but they're not particularly important. So I went to law school to be a criminal defense lawyer.
Just to dive in real quick on that front, it's funny because my family, my dad growing up owned a bookstore, and I think that was born out of his passion for reading and love of books, and selling them is very different than reading them. And he definitely got burned out from like the retail side of things and going to different book shows all summer long, and just the kind of wax and wane seasons of, kind of Christmas is always like super busy. Summertime is always super busy. And so it kind of definitely is tough running it that way. So it's interesting to hear that kind of passion project becoming definitely a burden. Just before we move on from that, what if anything, is there a couple of lessons, like takeaways from retail that you've applied into owning a law firm? What are some of the like key pieces of that's kind of been helpful?
Dude, first of all, one of the reasons I needed to leave retail business was I'm not a natural businessman. And I've seen one of your podcasts, at least one of your podcasts, on the subject of running a law firm and what we don't know as lawyers about business, because so many of us are in private practice, you and me both. I wasn't a natural businessman. And I had a partner, and he was like me, just not a natural businessman. We were great scuba instructors. I was a killer catamaran or a sailor racer, but I wasn't a businessman. And the takeaway here for law was, I've always been probably the loudest person in my law firm among my partners, is saying, I don't know this. I was a strong advocate for our hiring a business manager many years ago when we first hired one, because I knew what I didn't know. And I knew where my talents did not lie. And that's probably my biggest takeaway from it. I've become a barely passable businessman, but I did wake up after my stint. I was a law clerk coming out of law school. I was in the DA's office here for about 5 or 6 years. And then I went into private practice with Eben Rawls, as you know. And it was about 2 years after I left the DA's office, and I was Eben's partner, that I woke up and I said, what the heck have I done? I left business. I knew that I wasn't very good at business, and woke up to the reality that's just should hit everybody in the face. You go into small practice, private practice in the law, you're a freaking business person.
Yes, exactly.
And you're responsible for people's incomes and their family's livelihood, and there's no escaping that. So my takeaway was what I didn't know, and try to bring people around me, particularly in the management side of the business, who know what they're doing, and let them freaking do it.
Yeah, that's awesome. I love that advice. I think that was my big takeaway from my tax class in law school, is that I don't want to be in charge of anything related to tax. So that was the number one lesson learned, is got to find somebody that's good at accounting to figure all this stuff out. But I think that's so critical, and I think it's really important for us criminal defense lawyers to kind of hear that, because I think so many. when you have a small firm, you're running a business, but at the same time, I think for so many people in criminal defense, the passion is being in the courtroom defending clients, and that's 100% okay. I mean, especially if you've got somebody else that's either part-time or full-time kind of helping with some of the business management side of things, to where you can really 100% dive in on the thing that does bring you passion and does, you're able to help people in the way that you're trying to help people. That is just really powerful to hear, because I think some people get really frustrated at like, well, do I need to hang this up and go join the public defender's office? Obviously the answer is no, you don't have to do it that way either.
You don't have to, but for a lot of people, I think it's a really good way to ply our trade and to
Right.
to live through that passion that you're talking about. I mean, my partners and we've sized this firm in part driven to having a big enough organization that we can have a full-time business manager, and we didn't want to get any bigger than that, and we really don't want to be so small that we can't have those backups. The folks who are just pure solo practitioners, in and out of the courtroom and doing our work, and having to go back and balance the trust account every month and as you say, take care of taxes and take care of the paralegal and all that kind of stuff. That try to juggle all that. More power to them. For me, it wasn't something. And as I say, we sized our firm kind of right in the sweet spot where we could afford it. Barely, but could afford it.
Yeah, no, I love that. I mean, again, I think there's always this question about, do I need to grow do I need to grow my firm? Like, to what size does that look like? And there's so much freedom with being small, like, whether that's solo or just, one, there's a ton of freedom in that. There's also a ton of responsibility. So finding the size that is, again, most conducive to kind of how you're trying to manage the practice that you want to run. Like, there's no perfect size. Like, having 10 lawyers may be great for some people and a nightmare to others. Like, and that's totally fine. So I love that, the sweet spot has been found on your end, because I think a lot of people struggle with, am I big enough? Am I too big? And so recognizing why it is that you want to be a certain size is a really powerful place. And I don't know if you found that organically or if that was planned from the beginning, but what did that look like?
I mean, our firm's been around, starting with Eben and his old partner, Tommy Dickinson. I think the firm is pushing 40 some odd years old.
Wow, that's awesome.
I've been here for 20, I don't know, something over 25, maybe 27 years. Yeah, close to that. My partners, Amanda Mango and Katie Clary, we've been together for 15 years at least. So, we found things organically, I think, as most of us do. But I agree. I mean, I think that there's tremendous freedom in doing this and being your own boss and in having a firm with some partners, or even if it's solo. But man, except for those people who really like the business aspect of it, it's well to recognize that you have to find ways of controlling that monster, and not letting it rule you and detract from the joy that comes from doing what you and I do, which is helping people.
Yeah, 100%. Yeah, love that. Yeah, well, I kind of cut you off there in terms of kind of what led into criminal defense. You mentioned that you were at the DA's office. So between kind of starting law school and getting to the DA's office, what was the path towards that?
Yeah, no. So as I said, I went to law school wanting to be a criminal defense lawyer. And I got there and I kind of, 1L, you do what you do. But 2L, I really dove right into it. And so law school was just an exercise to get there. I stumbled. I mean, I was 32 when I started law school. And frankly, it's really helpful to have worked a hard job for a long time and then go to law school, because I think the reflex is to treat it like another hard job.
Yes.
You do it a lot. You study a good bit. I still knocked off at a pretty reasonable hour every evening because I was working my butt off from early in the morning. But all this is to say that that I ended up with good grades. I literally stumbled into them. I made law review and I turned it down, not understanding at all what the advantage of law review might be. I just like, I don't want to do that crap and check citations and write 50-page notes. And anyway, I turned it down, and friends of mine who had been to and dropped out of law school took me on an intervention breakfast at Elmo down in Carborough and said, "You moron, you want to do this." And that opened up the door later on of a federal clerkship after law school, which was fantastic. Just amazing. My judge from the Eastern District of Virginia, Henry Morgan, passed last year, and those connections I made up in Norfolk, Virginia were just, they're just fantastic. It was Morgan who, in his early career, had been a prosecutor in Virginia Beach, who told me, "I know you want to be a criminal defense lawyer, Tony, but you should start off as a prosecutor. You will learn a tremendous amount. You will make connections in whatever community you settle into that way." And as in so many ways, Judge Morgan was right. And I applied for DA's jobs, and I got the one here in Charlotte. I had no connection to Charlotte. I'd lived in the Triangle for about 16 or 17 years by the time I graduated from law school. And and Ann Tompkins, who was a very close friend of mine from law school.
She's amazing.
She's an amazing person. Ann and two or three others of my classmates, Andrew Murray, who later became the DA here, and of course was the U.S. attorney here.
He's out in Hendersonville now, correct?
He's in Hendersonville now. Yeah. That's right. They were all in the office, and I think it was Ann who walked into Peter Gilchrist's office and pulled my resume out of whatever size stack he had, and pointed out the desk and said, "Hire this guy." And I got an interview, and I actually got in an argument with the guy who was running the homicide team, a guy named Gentry Caudell. Gentry retired recently. Gentry was a really rough customer. And somebody had given him one of those law review notes that I'd written, where I just excoriated the state on a first degree murder case and the Supreme Court's ruling. And Gentry had the note on his desk, and he said, "So I gather you're against the death penalty." And I said, "Well, not totally. I mean," and he asked me to explain, and I explained that my feeling about the death penalty was, for the people who truly deserve it, the worst of the worst, I don't get tremendous heartburn over it. I don't think it's a good idea at all. But what I told him was, I do think it's a colossal waste of resources and a waste of a life. And so I left the office knowing I was not going to get hired, and got ushered back out. And I got a call. I drove back to Virginia Beach, where I was, as I said, I was clerking. And Gilchrist called me at 11 o'clock at night. This is not cell phones, like it's my phone hanging on the wall in my apartment. And he calls me, and I thought to myself as he said, "This is Peter again calling." I said, "Well, that's very kind of him to call me at 11 o'clock to tell me he's not going to hire me." And he said, "I understand you got in a fight with Gentry Caudell about the death penalty." And I said, "I thought it was a good discussion, Mr. Gilchrist." And he said, "Well, if I hire you, are you going to refuse to do capital murder cases?" And I said, "I probably would object to being on most of them, but no, I suppose I could do one or two of them. I don't have a fundamental objection to the death penalty beyond how dumb I think it is." And anyway, he said, "Well, I'm going to hire you, and I guess we're going to get a chance to test that out." So I'm sorry to speak so long on it, but how I ended up.
Definitely two takeaways in terms of, again, just like one personal experience, and then one, I think, really good advice from the federal judge that you were with. But in terms of, I after getting out of Charlotte Law, I went and interviewed in the Cabarrus County DA's office, and we probably spent 2/3 of the conversation about the death penalty, and it made zero sense to me, because I was like, I'm pretty sure I'm going to be doing like traffic tickets, right? Like, this was like, I really hope that this is not the stance of the county in terms of DWIs and traffic cases. But yeah, I definitely was on the opposite end of that from a philosophical standpoint. I kind of morally oppose the death penalty, so that got to be a interesting conversation. But I was not expecting that much of the conversation to be about the death penalty. So it's good to hear that you said that, because I was like, this is the craziest conversation I ever had in an interview, like going down this path for so long. So that was just funny to hear you say that. But in terms of the advice from the federal judge about becoming a DA first, I think that's so killer, like such great advice. I don't think anybody on the podcast has shared that was kind of like the intentional path towards criminal defense. I've heard a lot of, I've spoken with a lot of former DAs that kind of ultimately said, I felt like, this side might fit me better, or I wanted to experience the other side, or, this was just the job opportunity. But to kind of be clearly pushed into a DA's role to become criminal defense is so powerful, because I just think you learn so much as a DA that you would never see as a private or public defender. Like there's just aspects of it that are really helpful from a defense standpoint, to know what a DA is kind of logistically going through and how they think about a case, and what conversations are like with police, victims, all of these different kind of back end things that you just don't really think about on the defense side of things. So really, really good advice from that federal judge.
There's all kinds of paths up through to land where you and I are. It was good advice in the sense that, starting out, I did come out of the DA's office. As I said, after about 5 years, I came out of the DA's office with a skill set and kind of an internal knowledge. I don't think that the knowledge of how things go in a DA's office is held up very well over time, because as we know, it's changed dramatically. And when you're particularly when you're in a community like Charlotte, where though it's bumpy at times, there are enough assistant DAs over there and people running that office that we learn about how they do things, because we have enough of a collegial relationship with them. They give us a little bit of an internal, much less than it used to be, and that I think is tragic. But still, there are a lot of ways to get that knowledge. I got that.
Why do you think it's much less than it used to be?
Well, that's a don't get me started. But I'll just say this: the DA's office loses trials these days here in Charlotte at a rate which is vastly beyond what we used to do, and I think it's the plea negotiating, the so-called round table here in Charlotte, where they put together a whole group of people, lawyers, only one of whom actually knows the case, and they essentially vote as to what the plea offer should be. They're too harsh. And then I think that they lose trials because they are not really what do you win trials on? I think you win trials usually on a single theme, a single issue. Sometimes there's 2 or 3 that work for you, but more often than not, the jury is back there just talking about one thing. If they're talking about anything, if they're spending any time deliberating and there's any disagreement at all, they are usually talking about one thing. And when it comes down to the one thing, a group of people who are just hearing a summary of the overall case and how should the plea offer in this case be, they're essentially making a decision about a snowball instead of a snowflake.
Yes.
They've got this image. The decision makers at that round table have this image which is warped in the sense of what will a jury do with this, and that's the standard. The standard is what are our a reasonable probability of winning a trial in front of a jury is the standard, and I don't think that's where the plea offers come from much these days. To the extent that it's a senior assistant district attorney who can drive the discussion more, my impression is that the offers are better. But otherwise, they slouch toward trials that are a little bit too often weak when it comes down to that ultimate issue that's going to decide the case. And so as a group, I think the bar is beating them much more often than they used to.
And do you think that then is kind of creating like a friction point then because of that? Is that what's causing the kind of breakdown in communication?
I don't know that there's particularly friction. There are very, very good people in the DA's office, and particularly running the DA's office. But I do think that that there's just less interaction from a negotiating standpoint, from a case discussion standpoint, than there used to be. I chalk it up mostly to the idea of the roundtable, which was started by Andrew Murray many years ago, as opposed to an assistant DA who, if they wanted feedback about a plea offer on a serious case, they'd go to their supervisor and there'd be a one-on-one conversation. And the conversation wouldn't be about, here's my case, what do y'all think we should do? The conversation would be, I'd like to get a second degree, let's say, I'd like to get a first degree burglary out of this case, but I think we're going to have trouble on that. And I think the offer ought to be breaking and entering. Here's the issue. Instead, I envision the roundtables, because I'm not at them, as a much more generic conversation that's lost in the ways that I described a minute ago. So we're still talking to them, but I think that it's more ships passing in the night.
Interesting.
The defense perspective and the ADA's perspective, than it should be. And I think that's to some extent to the detriment of the system, particularly coming out of COVID, where the backlogs are stupendous. The length of time that people are spending in custody on serious cases because they're too poor to make their bond, or because some arbitrary decision was made about a curfew violation on their monitor. And then years, 2 years, a year or 2 years go by before they get a trial. The trials ought to be better trials on average, and there should be fewer of them probably, and maybe the backlog can be gotten through. To the extent that any one of my friends in the DA's office sees this and wants to cuss me on it, I feel you. I feel you. That's how I feel about it.
No, I think it's good. I think one of the goals, honestly, of the podcast, I don't have a mission statement or anything, but is to allow for better conversations between the state and the defense bar, for better conversations among the defense bar. So if there's anything that we can do collectively to kind of provide for better conversations, with ultimately leads to kind of better life, better practice. I mean, if there's a healthier conversation, healthier relationship, I just think that benefits everybody that's involved. So it's really good to hear.
That's a good goal. It's a good goal. Well, we got a little bit astray from
we did
from why I was a DA or how I was a DA. By the way, I had inside the DA's office, I had a reputation. Everybody knew that I wanted to be a defense lawyer. Gilchrist hired me knowing that I was probably going to go that way. I told him, honestly, I might like this so much that I will make a career out of it. But everybody knew that. And inside the DA's office, I was often regarded as kind of like a soft touch and a kind of a defense leaning lawyer. I loved the job so much, and I was so passionate about prosecution most of the cases I had, that in the defense bar way back then, I was regarded, some people said my nickname was Rush Limbaugh. So I had this sort of dichotomy going, and that's not actually unique. There are, you do see that in some prosecutors, that their approach is I'm not going to say frowned upon, but it becomes the butt of jokes around their own office. And the defense bar can't even see, they're getting that offer for a 15-year sentence from that person, and they can't even see that it's actually, it's kind of an ally, not an ally in defense of the client, but an ally in trying to see justice done. So anyway,
no, that's 100%. Yeah, 100%. Yeah, I love that. Well, I think in terms of, kind of obviously sounds like you were planning on going into defense, in regards to now kind of shifting into the backbone of the conversation, this kind of attack model that you have from the outset of the case. Where did that arise from? And just kind of give us the overall structure of kind of what that means and looks like.
Yeah, I think that there's actually a simple answer to that. That really arose and comes from the genesis of this firm. Eben Rawls, when I first came out, I'd had the prosecution side, and I understood that side, but I had yet to really get any vibe of what we do as criminal defense lawyers. And one of Eben's primary wisdoms, if you will, that he shared with me, many of them, but one of them was absolutely this idea that you jump on it, that you dive into it, both feet first, that often the first very few weeks of a case can be determinative of the client's outcome at the end. And let's remember, we're not jumping into every single case that the outcome is going to be a trial. As we know, right, it's actually a small minority of them that's going to be a trial. Many of them, the best outcome for the client, unknown to us when they first come in, is going to be a plea. There's a lot of them, and most people don't realize this, that the outcome is going to be a dismissal. And then, of course, always the trial is kind of the anchor in the ground that you tie off to, because any of those outcomes are going to be best if everybody understands that it's the trial that you're prepping for. So Eben's sharing that wisdom with me, it's immediately obvious, I think, when you think about those outcomes, what you're trying to get for the client in a broad sense. The outcome being, with the understanding that some clients, the best outcome is going to be a 15-year sentence instead of a 25.
Yes.
And you can't know that up front, but if you're basically taking that approach, you're going to jump into it and try to gain advantage from the very start. That is part of it, is trying to gain a leg up on the prosecutor. But that's where it came from. Eben instilled it in me, and it's lived on in our firm as kind of a spoken, understood theme of how we do things.
Yeah, I love that. I love that it's core. It's like a core value, core identity of the firm is jumping on it. So, what is that? What is that kind of? How does that look in terms of, from the time that you speak to the client? How are you uncovering things that you're going to take action on during the consultation? What is that kind of rush of action, so to speak, kind of generally look like on a kind of generic case? Well,
so there's kind of two goals of the very first encounter or encounters with the client, right? There's going to be a phone call. Usually it might be with a family member. There may be a jail visit if they're in custody, an in-person meeting with the client. And so in those first very few encounters, first call, maybe first consultation, what in terms of this attack the case aggressively early on and hard, we're really trying to focus on one thing, which is we're looking for advantage over the prosecution at every moment of the case. And it doesn't, it's not the same effort at different stages of a case. And we can talk about kind of what we want to know early on and what we don't want to know early on. That's a whole thing. But basically, the ultimate goal is to gain that advantage over the prosecution. And as you reach critical stages down the case, that's gonna have different looks. Critical stages are, when have we really begun hardcore negotiations with the prosecutor? What information's in hand? What have we chosen to share in an effort to try to get a dismissal or to get a good plea offer? And then, of course, critical stages is arraignment. At the end of that, what's the client's decision-making look like based on what you've gathered, based on what at that stage becomes here's your options. We have this plea offer. This is what a trial is going to look like. Advantage, it also comes down to having the ability to share with the client a full view of what's in front of them, of the choices in front of them in arraignment, and of course, then at trial. And cases, I talked about the idea of the snowflake. Cases go in lots of different directions. And it's really impossible to predict much of what's happening in that first meeting. But I mean, there's the obvious stuff that you do want to jump on. In a case where there might be, for instance, video from the surrounding area of what the crime scene is supposed to have been, and we all know that usually exists on digital loops. That's going to get overwritten, and you want to get out there and grab that stuff. But there's more to it than just, hey, we don't want video to be overwritten and lost forever, so we better jump on this. There's also the race against the police or the federal agents that are working the case. If your client's been arrested shortly after a crime, in this example, if they've been arrested shortly after a crime, the police are going to continue their investigation. They're going to be canvassing. And once the police get to a piece of evidence, a witness, if they get to everybody before you, your water is muddied by the time your own investigation gets started. So this is a situation where if they come in and they find video from a store across the street, I'll use the street crime example, they're going to take the data. And you're not going to be able to get it when they come back in many cases. If they find a witness or they're able to finally locate somebody who was just spoken to briefly by a patrol officer on the scene, but the detectives get back to talk to them, what's that conversation going to be? First of all, that's the first person that they've really had a conversation with about the case. If and when you or an investigator working for you reaches out to them, they're gonna start off with a greater skepticism toward you, and they're probably gonna call that detective, that agent, and say, "Hey, somebody from Scheer, Clarion Mingo has reached out to me about this incident," and they're gonna get this. They're not gonna get "don't talk to them," because we know that they can't say that. This is what they're gonna get. Well, you can talk to them if you want.
Yeah.
But just understand that they're going to use that information to try to undo the rendition that you gave us. So be careful in thinking of it, and you never get to talk to that person again. So getting out there early with the investigation is a really critical part of it. Another example that I think less comes to mind for people is, and this is more on the level of federal cases, all kinds of federal cases, but certainly exists in state trafficking, drug trafficking cases, where what's that best outcome from the client? Sometimes it's get right with the Lord, come to Jesus, and recognize that your goose is cooked and you need to get inside, and your best outcome is going to be to become a cooperator with law enforcement.
Yeah.
And there's a clock running on that, particularly in cases where there's 2, 3, 4 other people involved in the crime that know about it. First in the door is liable to, there's a couple of things that happen there. Number one is, first in the door is liable to get the best benefit. They came in and helped them solve the case early on. Judge, this is the person who should get the biggest credit for that work. But another thing is that the first person they talk to on the inside of a case, to their eternal shame, they tend to take that story and that's their version.
That's so true.
And then the second person comes in the door, and if they're like, well, that's not exactly true, because the person who actually located this source and was kind of the leader of our cell of this conspiracy was the guy you talked to first. Oh yeah, prove it. And you're already climbing uphill in a cooperation case if you're slow to come in the door, in those and many other ways. So what's the goal of that first not the first meeting itself, but the very early stages, is try to get a whiff of whether or not this is going to be a defensible case. And that's not to say you ever abandon the idea that you're out there doing your work, prepping for a possible trial, because it's the client's decision whether they go to trial anyway. Even if you could see perfectly clearly you will be convicted if we take this case to trial as early on as this, even if you can see that, you don't abandon it. The client may wonder why you're bothering, but for the reason I just said, you're working on it. But what you're trying to do, of course, in all of this is with the outcome in mind, understanding that there's going to be critical stages, understand that you want a leg up on the prosecution. You're trying to gather the information necessary to begin to make these calls and to bank evidence in the eventuality that you might take it to trial one day. So
yeah, I love all that. I think a lot of good takeaway points on that front. I think one thing for me is, when I first started practicing, it was kind of like get involved in a case, and then, the violence of action, so to speak, was, send in a Brady motion to the DA's office and wait for discovery to come back, which was no violence of action at all, right? Like, it's basically like, when can I get discovery? And it was always like, well, you're not owed this. This is district court. You can talk to the officer when they show up, which might be 4 months down the road. I mean, it was just, there was really kind of no intentionality of trying to use different legal instruments or kind of personal investigation to get the information. It's just like, okay, we're going to wait and see. We're going to look at the discovery, but the state is slow in getting this to us. And there are things that if you don't capture early on, just fall away. Personally, I've had a couple of times where site investigation immediately after the charge has just been huge. I had a client that was stopped a couple blocks from my office in downtown Asheville and was basically pulled over for going over double yellow lines on a left turn at a light. And when I went out there just a few days after the charge, the double yellow lines, because they had been driven over so much, it's like very narrow streets, driven over so much downtown, they were gone. Like for the 10 feet up to the intersection, there was like zero double yellow lines. So I had a picture of that. By the time it went to trial a year later, and I just drive by this location all the time, they were repainted. And so it's kind of like if I had waited for that moment, later to kind of go look at it or just kind of ignored it, it wouldn't have been there. And I think there's so many times where the season, the lighting at a particular time of day can be really helpful in terms of, well, yeah, I mean, if it's 7:00 at night in December versus 7:00 in June, very different in terms of what like an eyewitness might be able to see. So just going out and visually looking at that space, I think can be huge. But I love the kind of get to a witness first, which is something that I had never thought about because, not only does the officer, police detective potentially taint kind of, if you're asking leading questions or phrasing things in a certain way or painting the person charged in a particular light, kind of just frame that person's mind. But also, like you said, once a defense investigator or defense counsel reaches out to that person, it's almost in the witness's mind, like, I need to get permission. I don't want to get in trouble with the police.
Absolutely.
I need to get their permission to talk to somebody, or else, I might get charged. I don't want to get charged for perjury or say something wrong that I'm not supposed to say. So yeah, just the level of openness is completely different. So that's a huge point. I really love that.
Yeah, look, you make a good point. The going out to the crime scene early, and by the way, I do major felonies in state court and everything in Fed. So I still do street crimes. Absolutely. I mean, I've got a new case. It's a robbery. I've got three homicides, in the drawer right now, here with the team at the firm. So I still do street crimes, and I'm outing myself to say that when you just talked about going to the crime scene early, I'm going to say I used to know that. And to be honest, I've sort of fallen off of it here in recent years. And when you just said that, I'm like, yeah, you know what? What the hell was I thinking? Why am I not, hopping in the car with Eli or Hannah, when whoever's co-counseling with me on it? Why am I not hopping in the car at lunch that day and running out there and taking a look at things and seeing what's going on? Maybe not after the first interview, maybe not the day that they hire us, but why am I not doing that in the first few days? And so, thanks. You reminded me of this, and I'm absolutely going to reemphasize that because like I said, I used to know it, and I just realized I've kind of fallen off of it. Sometimes the facts you've heard something that's like,
yes.
I got to go out there and see that, but you just went out there to just say, let me go take a look, and without even anticipating what might be helpful out there on the scene. You're like, holy crap, there's no yellow lines to cross here. So I think it's been one of the great advantages in trial, regardless of whether I've found anything, simply because of like knowing the area. So the facts and law are often not on your side in some of these DWI trials, but sometimes you can get police buy-in if you're like, here's what the scene looked like, correct? Like you drove by this location and then you turn left onto this street. It was about 0.2 of a mile. You're not saying anything that is really outlandish, but you're telling the officer, I really know this particular space.
And I think that gets a lot of buy-in. So even where there's nothing really to be found at the scene, it's been a helpful practice to just go have a
You
look
know,
around.
we talked about these advantages. You're trying to gain advantage over the prosecution, and that includes law enforcement. And a phrase that I often use is and by the way, clients do not believe this when you first say it to them, but the goal is to know more about the case than the prosecution does
100%.
going
Yes.
into those critical stages. That's the goal.
Yes.
And sometimes it's not possible to know more about it, as you were just saying. Sometimes it's just like, I know what's gone on here, and let me demonstrate my familiarity with these facts. I'm not just walking in here having read your reports and talking about your version of the facts. I'm in here having gathered some, and we can agree on some stuff. But let me tell you where, right? And that interaction. Let's just talk about plea negotiation. A prosecutor who feels like the lawyer really is on top of this, really has learned a lot. Maybe sometimes you leak that you've got an investigator out there. You do it purposefully so they know that it's their narrative is not necessarily going to go unchallenged. This idea that you go in there with knowledge, and hopefully, and in some cases, it's not that uncommon, more than they know about their case. There's the advantage. And when your first interaction, so in Charlotte, the DA is going to be assigned sometime either while it's in probable cause down below or by the time it gets indicted. It's going to have a prosecutor on it. And sometimes I'll just interact with them so that they know that I am on this, that I'm on the case, so to speak, in the vernacular sense. I'm on the case. We're working this. And sometimes we'll just do things that are designed to make sure they understand from the very start, I'm up against a defense here that's going to be active, and yes. I better pay close attention to what's going on. And yeah, at that stage of plea negotiation, if there's something that you've shared with a prosecutor that they did not know, if you can, I'll get to that in a second, but if you've done that, I feel like most of the time you're actually going to make progress on the plea negotiation that they might not have done if all you were doing was talking about the nuances of their version of the facts. And by the way, the caveat that I just laid down in all of this is you're trying to gain all this knowledge, you're trying to get this leg up, you're trying to do it early because those interactions with the prosecutor or with the police are going to have them focused on the strength of what you're bringing. But you're gathering information and you're deciding how much of this can I share. If you're still a real prospect of going to trial, you find a golden nugget in an interview with a witness, often you can't share that, because if you do, the prosecutor's going to go tell the detective about it. The detective's going to go out and talk to that person again that they spoke to 2 months before, and they're going to have a presentation of that person that undermines the value of what, on cross-examination in the well of the courtroom, you might really be able to hammer them hammer the witness with, hammer the prosecution with. So there's a class of information that you, having gathered it, whether it's in this initial blitz or over the course of the investigation, that you can't share. Yes. Because it is a simple fact that most law enforcement officers, if they learn about a piece of evidence that undermines the case that they brought, the warrant that they got, and it's something that they can warp and do something with, whether consciously or subconsciously, they're gonna do it. So that's a caveat on how you use this information, gathered in the blitz or gathered at any time in the investigation.
Well, staying on the topic of plea negotiations for just a minute, in terms of kind of getting all of this information and evidence early on in the case, having a really good theory of the case, understanding of the case from the word go. In terms of plea negotiations, and this may depend very much on which prosecutor you're dealing with, which county, but do you have like a kind of general rule of, I want to take an offer to the prosecutor or ask for a dismissal before an offer is presented? Is there kind of a general rule on that front, or are you generally kind of waiting until there is a offer from the prosecutor before bringing some of this evidence to bear.
It's an interesting topic. So on the subject of the dismissals, and I'll say again for people who don't do this work regularly, you may be listening to this. On the subject of dismissals, they happen a lot. And particularly in civilian victim-related offenses, less so, for instance, in the white-collar realm, where the federal government's been investigating bank frauds, for instance. Right. They come with a pretty strong case, and the nature of the evidence isn't particularly squishy, but a significant number of reports of crime are lies. And particularly in the realm of domestic violence and sexual assault. I don't know what it is. When people are asking me about this at a barbecue, I tell them probably 1 out of 4 reports of a sexual assault is bullshit. And so in those places, you're starting with a class of cases where dismissals do happen, and there's a good reason for them. If there's a dismissal pitch, if I've got enough to realistically get a DA to look at it again and say, whoops, we're going to dismiss, that usually is not all the way down the road at plea negotiations. Because for me, I don't start plea negotiations, and I try not to let a prosecutor start a negotiation with me until I really feel like I'm really fully armed. Dismissal facts, they sometimes come out of these very initial investigations. I would say that the critical facts to getting the dismissals I've gotten, probably in a third of those times that I've gotten dismissals, have actually come in this very initial phase. Whether I shared them immediately or not, that's a different matter, but that often comes in that initial phase. So on the dismissal front, the takeaway is, particularly in those type of cases, it's not at all uncommon. And yeah, the blitz is part of that. The plea negotiations, I'm taking up my version of the facts kind of when I'm ready for trial, not the grinding prep of trial, but I know where I'm going. I know what issue or few issues that are going to really create a doubt in the jury's mind. I know what those are. They usually come in the realm not of this is an exculpatory fact and I'm going to prove to you that he didn't do it. They usually come in the realm of here's where the reasonable doubt lies, right, for the jury's benefit. That's usually the point at which I'm starting to engage in plea negotiation. In most jurisdictions, certainly in Charlotte, I practice all over North Carolina. I've represented people in about, 15 other states. In most jurisdictions, the prosecutor has made an offer because it's part of their process not long after digesting the case and providing discovery to make an opening salvo. I ignore that. I don't talk about that with them no matter how many times I see them in a courtroom until, as I said, I feel I'm ready for a negotiation. And continuances in these scheduling conference settings and so forth, those were never a topic for here's what I'm finding or here's what I'm thinking or what do you think about. Where possible, I'm waiting and I'm not letting myself get dragged into a negotiation until I'm ready, and where possible, that's face to face. Yeah, or Zoom. But it's pretty carefully laid out here. Our team, I think that we've usually got a written outline of our points. It may just be 2 or 3 bullet points, but we know what we want to share. We know what we want to ask for in some detail. We've played checkers, not chess. I won't claim chess, but we played at least checkers and figured out like what their likely response is going to be and how we're going to, if not counter it, at least slow their roll. Hell no, I'm not going to do that isn't an opportunity to go away and come back with an offer that's not as good as your first one. Hell no, I'm not going to do that from a prosecutor is an opportunity to tell them why they ought to stop, think twice about saying no. So we will sometimes pocket a piece of information to not share in the very first round when we're making a proposal as to what the plea ought to be, but we'll pocket it for the response to when they say hell no.
That's interesting. Yeah, that's interesting.
So it's a pretty purposeful process, and I think that just that describes what you were talking about.
Yeah, I love that.
And it's not a secret either. Um, I think that it's you're not you're. I don't think plea negotiation is a gotcha moment. It's really not that. But what it is it's a case study in human nature, having very little to do with the law. So another thing that I say a lot to people, not to prosecutors, but maybe one or two will watch this, but maybe more. But what I say is you don't want to get involved in a negotiation early, because human nature is that once you've gotten a no, you've got a much steeper road to get them to come to your place.
Yes, 100%.
So don't start until you're ready, because you don't want a hard no that you just leave on the table pregnantly. Well, thanks. I'll get back to you in a month. And ask them again. It's much harder to do. And similarly, in that first meeting with a prosecutor, and there may be two or three, four, in that first meeting with a prosecutor, anticipate where the no is going to come from, and have something ready to keep the door cracked open. Have something that is basically the equivalent of sticking your foot in the door while they're trying to close it, so that you can continue a conversation that, as I say, human nature isn't already, human nature hasn't brought them to a hard no already.
Just to follow up on that question, in terms of, I assume, and I don't really do any federal work outside of federal DUI cases. So that's pretty low tier. There's not,
you guys have got a nice bunch of them up on the parkway, don't you?
Yeah, exactly. So there's, that's very low tier for the U.S. Attorney's Office. But I assume that on most of the federal crime spectrum of things, the U.S. attorneys have a generally pretty good knowledge of a case that they are assigned to. On the state side of things, where you have a prosecutor that might be kind of swamped with cases, has a lot of files on their desk, is there anything that you are kind of alerting the, is there a way that you're trying to go in to the state prosecutor's office, making sure that they have like a basic understanding of the case before you begin that negotiation? How does that does that make sense?
Yeah, it makes total sense. It sounds like you and I probably take the same approach on this. I don't assume in any prosecutor's office that they really know the facts well enough to be able to relate to my argument about their case. Excuse me. To be able to relate to where I'm trying to point out to them there are weaknesses here, or there's an element of the crime that you want me to plead to that's problematic for you. I don't assume that they know all those facts, and often particularly in more complex cases, we've discovered something that if you weren't approaching it as a defense attorney, you wouldn't think to really study on. And they shouldn't be faulted at all. And it doesn't even take a heavy caseload for them to have a good excuse to not be aware of it. But yeah, as a general, kind of from a general standpoint, there are certainly situations where I think that it's helpful as you begin negotiations to talk about what you think are kind of the givens in the case, and make sure that y'all are on the same page. We can be wrong too. And we can miss things. I mean, some of our discoveries in state court now, you know this, discoveries can come in gigabyte quantities.
Right.
And in federal court, we have more than just a handful of cases over the last few years that are terabyte quantities.
Yeah, that's wild.
So really knowing everything that's in the case, we've reached a point where particularly in the realm of cell phone and computer forensics, harvesting of data, we've reached a point where you can't pretend yourself as the defense attorney to know it all.
Yeah.
And that conversation gives you an opportunity to also find out whether the prosecutor is onto something that you're not onto. And you might want to go scurrying back to your office and reevaluate the whole conversation based upon having learned something from them. This morning, give you a story. This morning, this goes to two things that we've been talking about. Okay, you mentioned discovery. Putting out a basic discovery request, asking for Brady information, waiting for discovery to come back. I won't get on a soapbox about this, But most places in North Carolina, prosecutors have become shamefully slow at producing discovery.
Yeah.
They're violating the discovery statutes in doing that. Here in Charlotte, they are violating the local case management procedures on it. We as a bar, all of us, myself included, have just gotten complacent and letting them get away with it. Recently, our firm has started doing motions to compel discovery. We have a child sex offense case that came in several months ago, arrested back in the end of September or early October of this year, of last year, 4 or 5 months ago. And it was allegations that stem back to 5 and 6 years past. So this was one of these, recent revelations, the alleged victims being in their early 20s, now claiming abuse when they were teenagers. So all this is just to say that we went 4 months and didn't have discovery. We sent a discovery request out. We still email a copy of a discovery letter and file it in e-courts. And we sent it out in mid-October, and nothing happened. We went through the first scheduling conference. I'm making the story too long. We filed a motion to compel discovery.
I got time. So if you, I have a couple more questions after we go through this. As long as you're good, I'm good on my end. So you take your
that's
time.
Fine. I'm fine. So the long and the short of it was, reached out to the prosecutor with the second scheduling conference coming up. When's discovery coming? And we learned, that the DA's office didn't have it yet. They didn't have the CMPD file 4 months afterward.
Yeah.
And that first email to the prosecutor was, we're going to file a motion to compel, unless, of course, it's coming in the next couple of weeks. And then she said, well, I don't even have it. So we filed a motion to compel, and you know what happened. We got it docketed for a hearing next week, and yesterday discovery was posted, and we got the discovery. Now, so
not a coincidence.
Right, not a coincidence. So what do we find in the discovery? Because we had begun investigation already, but we'd also decided, let's stop. We're wasting money. We don't know enough about the allegations. And we sure as heck didn't know enough about the allegations. I won't get into details about it, but what came in that discovery was some very strong evidence for the prosecution. And it completely flips the script. So, on the subject of like what's driving us and where we're going, we learn things about our cases, surprises about our cases all along the way. And discovery is one of those things that I honestly think we all ought to be 100%. We all ought to be pushing people for this. We've had a couple of hearings over the last year on them. The judges have been absolutely receptive to it. And a couple of years ago on a first-degree murder case, we had a discovery, a motion to compel discovery that strategically devolved into a mini litigation over the use of geofencing. I won't get into it, but this is a process by which they're not doing it anymore. They can locate a defendant's phone near or in around a crime scene. And we ended up using the motion to compel as a mini trial on that. And the judge told the prosecutor, so first of all, you're going to get them this stuff. We won the motion to compel, but they also told the prosecutor, I believe the phrase the judge used was, I think that Mr. Scheer is reading you the future of your evidence from those search warrants, which was to say, rethink it. That murder case was dismissed 2 months later, after the client had been charged for about 2.5 years, I think. So I'm sorry, Jake, I forgot exactly what.
I just want to piggyback off of that for a second. I think that that's really helpful in terms of, kind of making sure that the prosecution has a kind of understanding of the cases, how we kind of started going down this path. But I think that, again, just to kind of maybe put us in the driver's seat as a defense bar, I think I've been a part of and seen a lot of times in courthouses in the lawyer's lounge, a complaining session, bitching session about the time it is taking to get discovery. And I think much better use of time is just to collectively push on discovery, whether that's through discovery motions, motions to compel, subpoenas, whatever it might be, to have a collective strategy of trying to kind of change the policy. I think probably about 5-6 years back when the video law came out about basically kind of being able to get that through a civil process. I started filing for that on some of the DWI cases where it was just taking a long time to get body camera back. And so I had a couple of hearings with the scheduled. I did this on about 6 or 7 cases all at once. I had multiple phone calls with the attorney representing the sheriff's department. We had a hearing scheduled, and ultimately he had called the DA's office and basically said, "Here's what's going on. I think he's probably entitled to this. What do you want me to do?" And so the DA in charge of kind of like the technology side of things in Buncombe County, Rodney Hasty Notestis, great guy. He called me and said, "Jake, what's going on? What are you doing here? Like, why aren't we going through discovery?" And I'm like, "Well, I've asked for this in discovery and I don't get it back. So this is just like a way to get it faster." And he's like, "Well, if you're just trying to get the video," I'm like, I just want to get the video. That's all this is about. And then they figured out a way to get it streamlined and sent out. And so I think sometimes it's just like the mechanics are not in place. It's not as though, collectively, again, it helps the DA's office to get discovery into the hands of defense lawyers because the trigger can be pulled much earlier one way or the other once you have that good or bad evidence back in your hand. It's kind of like the waiting game is eliminated. So I just want to kind of re-echo. I think it's really important as a collective to push on that front instead of just whining about it, which I've done a lot of. I've whined about it a lot. So
we all have. We all have. And as I was saying, I think collectively as a bar, look, they're really busy lawyers with lives of their own, prosecutors, that is, and if we, we're complicit if we don't kind of hold their feet to the fire. And if only 1 or 2 people are doing it, if it's a handful, they'll grease the squeaky wheel and not change process. But if a good group of people in any given jurisdiction sort of take that up, it'll change things. In some ways, I guess I'm saying this is more our fault than the DA's office. They will do what comes naturally for all people. Right. And take the path of lesser resistance unless we take action. And let's talk about why we first became lawyers. We're here to help people. Our clients are sitting out there with sometimes, with charges hanging over their head, and that is always potentially life-changing. And it doesn't matter beyond traffic tickets. It doesn't really matter what the charge is. And so I suppose there's the argument to be made that making this process work faster, taking away the unknowns, cutting down the number of nights that they can't sleep well because something's hanging over their head, is really part of our job. And it's
much better to know that you're going to jail for 15 years than to not know how long you're going to jail for. I mean, it's
yeah. Well, and even if it's not know what's going to jail, it's like, so this guy that I was just talking about, he was under these charges for 4 years.
Yes.
All he's got is the warrant allegations.
Yeah, it's crazy. Yeah, it's a crazy thing.
So he's completely in the dark about what it is he's facing. And knowledge is if knowledge isn't always power, I think it's always, calming.
Yes.
You have a sense of control,
100%.
even if you don't have actual control.
Yeah.
Anyway, all that is to say that I love the idea of going around the whole criminal process and just saying, I got a statute that'll do this on the civil side. I don't need you. Certainly gets the attention of a prosecutor, and it's a great way. It's a great way to approach that. People have used FOIA requests for that from time to time. I've used them once or twice. The problem with FOIA is it's slower than the slowest, prosecutor I've ever run into.
Well, just to kind of step back, And then I kind of have like a final final question after this, but to step back a little bit, this is something I have very limited experience with, and so I'd love to get your thoughts on it. You had talked about, one of the reasons for trying to get information back early, specifically on like drug trafficking cases where you might be able to act as an informant, potentially, if that's kind of the right move. What is the what are some of the kind of processes or thoughts that you have when you are taking a client to go speak to police about a case that they have been involved in, things that you want to make sure are hammered in before there's any type of conversation, when you potentially, exit a conversation? What are you kind of going over with client? I know that's a lot, but are there, kind of general practices with regards to, hey, we should go to police? That's like maybe our best move right now. What does that kind of conversation look like with the client? And then, what are the kind of real black and white items that you want to have laid out when you go talk to police?
Yeah. So this is an area that this is one of those areas that experience is really, really, really valuable at. I don't like to stand often on like this is something for lawyers who've been doing it for a while to engage in, and if a person's pretty green to that area of the law, they ought to get a wingman. And here's the reason: this is really more art than science.
Okay,
and it begins with that evaluation, and this is an area where the lawyer has to inform and advise their client. Here's where I see the case. This may come from conversations with the lead detective or the agent that's been investigating it, and or the prosecutor themselves. Sometimes you can get some early indications. They may be asking for the client's cooperation before you even meet them. That is right after the arrest. The job is to figure out whether there's any alternative, because once you go down that road, you're almost certainly headed toward a guilty plea to something. And in these kind of cases, it tends to be serious and prison time related pleas, even with cooperation. So the first thing is to get to that point where you're in a position to tell the client where they stand, and with a qualifier, with a caveat, that is to say, I can't be sure, but based on my experience, based on what I've learned here and what I've learned from you, but based on what I'm hearing from the other side as well, I think there's a good chance that you need to cooperate if you want the best result. Let's just use it's oversimplification, but the shortest prison sentence. And I always tell them, only you really know what they've got out there on you. And I'm not necessarily asking for you to tell me that yet. But if you want to go down that road, it's time for us to have real communication. Drop back for 1 second. There's a lot of cases where in the early stages of representation, we don't want to put the client in a position where they're going to give you an ad hoc version of a confession. They sometimes need their recollection refreshed. They sometimes need to understand that if they're going to start telling you the truth, it needs to be complete, right, not some minimization with a kernel of that. Because at the end of the day, if there is a trial down there and they're going to be testifying in that trial, as we all know, they testify to something that we have reason to believe isn't true, even if they're testifying to the truth and we let them give an ill-conceived, partially true statement to us early on in the case. We have to be careful about that. So often we're reaching this point, and it is early on, where we're talking about cooperation, and we haven't had a tell me everything conversation.
Right.
But now's the point to say, if you want to explore this and you may have a better idea, you're telling them what the prospects are for potential sentences and what maybe cooperation could get them as and again, all qualified with I can't be sure, but this is typically what you might be able to gain. Do you want to go down this road? And if the answer is, yeah, I think we better, that's the point at which you have the conversation, which is, all right, here's how this works. You need to go into this conversation with them assuming that they know everything. Particularly with the feds, they know a lot more than a lot of people think,
Right.
obviously. And you give them some examples of the kind of information they may have gathered about them, what they may have that they don't know about, to try to convince them. You have to be completely honest. And we're going to start with that with us, with your lawyers. And we're going to hear that from you. We're going to be, and then we're going to be engaging in essentially an interrogation of our own, testing what they're saying and trying to see if there's traps. Basically, what we're trying to do is squeeze all the natural tendency to lie or minimize their conduct out of them. Because the best cooperator is the one that goes in, and on the first meeting, very often we're doing more than one meeting with law enforcement when we do go down this road, but on the first meeting, they accomplish two goals. Number one, they leave the investigators believing everything they said, and the truth is the best grounding point for that. Without minimizing, that's a huge thing that you have to get rid of. And the other thing is that they like them, that they feel like this is somebody that they could have met at a cocktail party or a barbecue, and that they like them, and that there's a person. And this is what I sometimes tell clients: you want them to walk out of there, if possible. You want them to walk out of there saying, "I met this guy in a different context. I'd hang around and have an extra beer talking to him."
Yeah,
because I like and you want both of those things through the process of cooperation and being truthful, which, as we know, is so difficult for the majority of clients, is really important. So the lawyer's job is to work that like a dog on a freaking bone until you really feel like you've gotten there. Now, we have clients who are they're just incapable of getting there and pulling our wool over the eyes. We have some clients where we did this about 2 months ago, the person who was going to do that, and we basically had to tell them, don't believe you. They never changed their story, but we told them, we don't believe you. And we think that the police are not going to believe you. And you go in there and you do this, you might as well just go and give them a load of bricks to build a prison on top of you.
Yes.
Because when you do go in and cooperate and you lie to them, you absolutely make your situation worse. Now, sometimes we can put that back together a little bit, but the risk that they will really make their situation worse is very real. So it's our job to be sure. It is our job to be sure that we've worked with that person as they come to us. It's not our job to make them like every other client. It's our job to figure out what this client's difficulty in this process will be and find a way of penetrating. And we fail when we waltz somebody in for cooperation and are blindsided by the fact that they were lying to us going in there, that they persisted in this lie. I had a federal client who lied not once, not twice, but 3 times with the FBI. And you know what finally got him? And we were telling him, that was one that we told him, you shouldn't do this. We don't really believe you. But he insisted on it. He wanted to do it. He'd been in custody in London, awaiting extradition for 1.5 years before he was brought here, and he just wasn't thinking clearly. And we didn't get to that point with the client until after 3 sets of lies. And what broke it was the FBI going back in and pulling data that most people don't think they can get. They traced his crypto payments directly to his apartment in North London through IP addresses. And these transactions had taken place 4 years earlier.
Yeah, that's
and
unbelievable.
They brought that data and laid it in front of him on the third time lying. And that wasn't one where we were surprised, but we walked out of there, went to visit him back in the jail, and said, "This is what we've been trying to tell you." And we know exactly how that worked out. He had a co-defendant similarly situated who didn't lie, who got 4 years, and our guy got 11.
Yeah. I think that's such good advice. I mean, I really do think that kind of going into it with a clean conscience. I mean, just knowing like this is 100% sent. You can't go partially in. Again, I have very limited experience. I've done a couple of these kind of police interviews, both times with other lawyers kind of leading the conversation. So I've really never actually kind of been kind of guiding the confession slash informant role. But it's so interesting to hear you say that, because again, the goal of police in that to some extent is to make sure that they are getting as true a story as possible. Is this person going to help our case or blow it up potentially? And so that's really a powerful thing that just, I had not kind of gathered that. Looking back, I kind of understand some of the questions going into it that these other lawyers were asking, but that makes a lot more sense in that light, because you really do have to assume they know everything.
I mean, when you get to that point where it's like, this is the reasons you might want to cooperate. And by the way, I think it goes without saying, but this is the early stages of the game. The earlier, the better, as we said before. But when you get to that point, the preparation of a client to go in and be a cooperator, I would say is usually 4 or 5 times as much time as the interview. So if we're going to be in there in an interview for 2 hours with them on the first pass, then we've usually spent 2 half-day sessions leading up to it to anticipate what the questions are, to ask them the questions, to hear their answer. It gives you many, many, many opportunities to challenge whether they're really being completely truthful with you. And so the preparation of the client for it is a big chunk of the battle. There are some clients who are going to be able to give the facts and do so very dryly and do a pretty good job, and they're going to get help from it, better than if they went to trial, a lot better. But then there are a lot of people who, if they get to a place where they're comfortable enough with the story that they're telling, and they're comfortable enough with the process of being interrogated and interviewed in that way, many people, the majority of people, are actually going to feel comfortable. They're going to be themselves. And that, again, to that second point that I said, those are the people that are going to walk out of there with the law enforcement agents liking them. And this is critical, because there's in this district in federal court, there's kind of a rule of thumb these days. A basic cooperator who gives actionable information to them is going to get maybe a 20%, 25% recommendation for a downward departure for their cooperation. The ones who get the same thing and get 40 are the ones that the cops liked. And frankly, ideally, we're trying to get our client in with law enforcement 2 or 3 times, because it's those cycles where they get to know one another. You know you're doing good in a federal debriefing when the second time they bring your client from the jail to the FBI office down our FBI office down in South Charlotte. When the second time that they bring them in, they've stopped at McDonald's and gotten a meal. Yeah, that's awesome. He's been in the county jail for like 5 years, and he plops himself down in the chair at the FBI office with a Big Mac in his hand. That's huge. Why I say it's more art.
The human element, it never goes away. I love that. Well, I guess as we come to a close time, I have kind of one last question that I ask most of the people that come on the podcast, especially with your level of experience, and that's if you had kind of one tip, trial tip for young lawyers, what would that be?
Well, it's an impossible question, Jake. Thanks for asking. And I'm sure everybody appreciates how
multiple. You can give multiple. There's obviously no one right answer. So whatever you want to go with it.
Well, look, what I would say for lawyers that are coming up in criminal defense, I guess all I would say is the obvious thing, which is do your best to put yourself in a position where you can try a ton of cases. You really do need to come out of law school or learn it after law school, the rules of criminal procedure, and particularly the rules of evidence. You really do have to do that. And you don't have to be like, know them chapter and verse. I've forgotten enough of this stuff that I still have to go back to them on a pretty regular basis. But the issue spotting ability in those things, obviously that's important. But realistically, it's like, I was a gymnast. It's like learning a new trick.
Yes.
For a parallel bars routine, you do it through repetition. You get good and you get clean at it, and you make less mistakes at it. The more you do it. So And it's not always easy. A whole lot
No.
of lawyers, they can't get a job in a DA's office or a PD's office. That's not by any means fatal. Some of the best lawyers I know didn't have those kind of high trial cycle experiences. But you do whatever you can to put yourself in a place where you can try a lot of cases. And if that means, if that means volunteering with a lawyer that's willing and wanting to mentor you some to just sit second chair, then you do that. It's really good to sit there and watch a lot of trials. Anybody can do that, and that is definitely good and helpful. But struggling to put yourself in a situation where you try a ton of cases is there's no getting to being a really good criminal defense lawyer until you have tried a ton of cases. And juries are a different thing than bench trials in district court in North Carolina. They are, but the piece about working a jury, here's what I would say about that. A, you're going to have to study on it when you do get there. If your experience is mostly district court, that's great. That's most of the battle. When you get to jury trials, you're going to have to hone some skills. But I'm going to also say this: if you didn't have the basic building blocks of a good jury trial lawyer, then you're not going to get there anyway. Mostly, I don't distinguish between district court and jury trials. For the biggest piece of the skill set you need, it's tons of trials in any forum. That is what you got to do, and that can mean compromises in your income, compromises in your quality of life, because trials, as we know, are if you're doing a lot of trials, you're burning the midnight oil.
Yes, you are. Yeah.
There's compromises to get there, and you don't have to do it for the entire career. But you said young lawyers, try every single thing you can do. Be in trial as much as you can do. I would dare say that if you get a relationship with an experienced lawyer who does try a lot of jury trials on that subject, they'll get you into a second chair position, and you'll start picking up those skills. You don't have to have a client base that's going to go to jury trial. Hey, we know very few cases go to a trial, and felonies go to trial before jury. You don't get that quickly in most realms except the PD's office or a DA's office. But you can get there lots of ways. Be creative. Try tons of cases. Is my.
I love it. I think there's no experience like the courtroom. No matter how many CLEs that you attend, or even things that you watch, trials that you watch, and you do get a lot through second chairing a case. But until you're there making mistakes of your own, there's no experience like pushing it to trial. So I love that advice. Thank you so much for sharing with the listeners. I mean, it's just so amazing to have somebody that's been doing it for as long as you have, and just kind of the plethora of different trial types and cases that you've walked through. I mean, it's really helpful, and I love, again, the mentality of go to war from the word go, because I just think that there is stuff that you can dig up early on in a case that is lost, or really just doesn't make the same difference later on. So I really have loved focusing in on this, and I'm really glad that you brought this up as a topic.
Well, listen, I really appreciate the time. It's been a really good conversation, Jake. Really enjoyed it.
Yeah, thank you so much.